And a federal judge in D.C. is ordering the Justice Department to release a memo that former Attorney General Bill Barr says helped guide his decision to not charge then-President Trump with obstruction at the end of the Mueller investigation. In her ruling, Judge Amy Berman Jackson sharply criticized Barr, saying he was disingenuous about the process. This all stems from a Freedom of Information Act lawsuit brought by a government transparency group that sought the 2019 memo, but the DOJ refused to provide it, saying the document represented the private advice of lawyers. Barr could not immediately be reached for comment. Joining me now is former FBI General Counsel and a lead member of the special counsel team headed by Robert Mueller, Andrew Weissman. He is now a law professor at NYU and an NBC News legal analyst. He is also the author of Where Law Ends Inside the Mueller Investigation. Andrew, great to have you with us on this. Based on Judge Jackson's ruling, what do you expect to see in this memo?
Well, this decision by Judge Jackson, who doesn't mince any words, is a bit of a bombshell in two ways. One, it's not new to your audience that the Attorney General misled the American public in his so-called 4-page summary. What is new is that Judge Jackson has seen in camera, meaning she herself has seen the memoranda that she has ordered to be disclosed, and she says in her decision that it provides further evidence of the deception played by the Attorney General, including his statement to the American public that Robert Mueller left it to the Attorney General to decide whether the president had committed a crime, and she says that's simply not the case. The second part of her decision that was pretty upsetting, and to many of us, was that she said that the Trump administration lawyers who presented the arguments to her were misleading to her. So she was obviously, as a federal judge, quite upset that those statements were made to her that she said were essentially belied by the actual submission, which they fought to have her not see, but she insisted on reading. And when she read it, it led to this decision saying that the memoranda has to be disclosed.
Yeah, so you raised two very important points there, which ultimately begs the question, what do you think the Justice Department now, this current Justice Department under Merrick Garland, will do, can do, should do?
So that's a hard question because, of course, you and I don't know what is in the sealed submission. One part of her decision seems pretty unassailable. She says there is a part of that memorandum that is clearly not legal advice and that she had not even been told and no argument was made to withhold that. So she was quite upset, it seems, by the fact that this was something they just decided not only not to produce, but not even to address. So it seems very hard for the current Justice Department to say that that part should not be withheld. I think what the current Justice Department will do is see whether there are really legitimate arguments, just legal arguments. So even though they might disagree with what the Attorney General Barr did here, if they think that there is a legal basis under the Freedom of Information Act to withhold these documents, they may take an appeal, but my bet is that they won't. Remember that Attorney General Garland, in his confirmation hearing, said that he thinks that FOIA needs to be very liberally construed in favor of disclosure and transparency. So, I would say, my money is on this department not appealing this.
So let me ask you, if I can, about another subject, and that has to do with this breaking story following last week's raid on Rudy Giuliani's home and office in Manhattan. The New York Times reports that a lawyer for Giuliani has had conversations with a lawyer for Trump about whether any material seized by the FBI could be protected by attorney-client privilege. A court filing Tuesday showed the U.S. Attorney's Office in Manhattan asked a federal judge to appoint a special master to review potentially privileged material seized from Mr. Giuliani. Could this potentially be a significant roadblock to that investigation?
Not at all. This is something that is, I won't say fairly routine, but this is something that federal prosecutors do. In fact, any prosecutor does when they think that they're going to obtain documents that could be covered by the attorney-client privilege, which is to ask the court to either appoint a special master or, more common, to create a so-called filter team that would review material to screen out any attorney-client communications so the team that is actually investigating doesn't get access to that. We did that, for instance, in the special counsel investigation, and it works very well. The only thing that this means is that the process is slower because you have to allow that filter team time to review and to discuss it with, Mr. Giuliani and potentially the former president to make sure that they're screening out attorney-client information, but only material that is actually subject to that privilege.
Hey, thanks for watching our YouTube channel. You should know that you can follow today's top stories and breaking news and catch up on your favorite MSNBC shows all in one place. Download the NBC News app today.